sure you can hear another laughter in the background. Belongs to a friend of ours who's here with us this morning.
Yes.
Habari.
Salama sana.
It's so good to see you.
I'm also grateful to be here.
Good.
And we thank God for the opportunity.
Oh,
Amen.
good.
Amen.
We're talking to this. That's a voice of. No, you're going to introduce yourself.
Yes, it's
Yes,
just the first time.
Yeah, it's
Yes.
such a first guy. Twende kazi.
Chege Kamau advocate.
Yes.
And I am counsel that is passionate about sharing legal knowledge.
Legal knowledge, yes.
Yes.
And today he's going to be doing sports on behalf of us.
Did you indulge in any sports in
By
school?
the way, you know.
Yes, I did karate.
Wait a minute.
Yes, but unfortunately I've become rusty. After high school I did not pursue it.
I have a question.
Unaweza inua mtu sasa ukipigwa geta.
Amekuwa rusty sasa.
We don't care. Rust is for a little while.
Yes, I have the techniques to defend myself.
I have a question.
Yes.
Those noises that you make, are they
Do they
necessary?
mean- yeah.
Do they mean anything?
Are they symbolic of pain or?
You know, the karate and martial arts
Yes.
really has an origin from the Chinese,
Yes.
Asians,
Yes.
and therefore, because of that origin, we cannot say that it really has some meaning.
Okay.
But because of the energy that is involved
Okay, yes.
during this movement,
Katawan,
you find yourself really saying this.
My God.
Doing those.
I cannot believe you
That's really
did
cool.
karate.
We have
Yes,
never
we did.
met anyone. In fact, people say I used to be in basketball, I used
Yeah.
to be in rugby. Today we have had
You
karate.
are our karatian.
Yes.
Wow.
Karateka.
Hi.
Yes.
Karateka.
So good to see you, Bwana Wakili. Last time was fantastic. We had on one of our favorite shows, best shows, last time when you were here. And today we yani tumechangamka.
Yes, we have.
Yes.
We're going to be talking about employment rights. And
Yes.
listen, you will send your questions, your messages. The number is 0702-969-969. And even if you give us your name, we will not read it out. We don't want victimization.
No.
Okay? But you got to ask questions today.
Right.
So that you can get knowledge is power, information is power. So you can get information about your current situation
Right.
or the lack of thereof. So let's go ahead and start off. I know we're talking about employment rights.
Yes.
But I know you have you want to start us off before we get into sports in about 4 minutes.
Yes, the first thing that I would want us to really understand is the question of what is an employment contract.
All right.
It is very important to know what entails an employment contract.
Right.
Because you might be working and you believe you are employed, but you're not. On the other hand, your employer might be of the view that he has not employed you. But when you look at the situation,
Yes.
it appears or it comes out that you are employed.
Uh-huh.
So it is important for us to understand that
Yes.
when you talk about an employment contract, it can be either verbal, it can be written, or it can be implied.
Oh, implied. What does that mean?
Implied means looking at the circumstances surrounding a situation, the conduct of the parties, and after you have analyzed that conduct, you come to the conclusion here there is an employer-employee relationship. So generally,
okay.
When we talk about written,
Right.
it is not controversial. There is no gray area. It is written. So you have a contract.
Right.
But what can bring a controversy is a scenario where somebody has been in the organization for a number of years, but eventually you argue that there is no employment between you and that person.
Right.
At that particular moment, the law looks at the conduct, circumstances, and concludes that there is an employment contract or relationship between the parties.
Oh.
That is what we mean by implied.
Wow.
It is very important for employers to always ensure that they put down the employment contracts with the employees.
Yes.
Always.
So gentleman's agreement, verbal, those
Hakuna
ones.
kitu kama
It is good, but if there are some disputes that will eventually get to court, the employer might lose because in the absence of an
Yes.
employment written contract,
Right.
the law will be applied in that situation.
I think, Bwana Wakili, we need to first define what is an employee.
Yes.
Because if I go and work at Danko's garden
Yes,
and try,
I tell her, by the way,
yes,
come unituelele
and it's only
Lara.
2 hours.
Yes.
Am I an employee?
Yes.
Or if I stay with Danko for, let's say, 7 years, but every Saturday I'm going to go clean the house, does that make me an employee?
Mama Safi.
Yes, Mama Safi.
Now, you bring in the issue of an employment contract and where we call a service contract, where you have a scenario where you are providing a certain service in a manner that is not consistent. So you do not go on a daily basis,
Right.
Yes.
but you do it periodically.
Right.
All right.
Therefore, in that scenario, we can say there is a contract of service.
Contract of service.
For you to be able to say that somebody is employed by another one, there are certain things that you employ or you use criteria. One of the most used criteria is what we call the control. The control test,
Yes.
where you ask several questions. This person who is in this organization,
Right.
does he do or does she do all that she does upon instructions? Do we have the boss instructing this person what to do, at what time to do, and how to do it?
Yes.
That is a control test. Another scenario or criteria would be a scenario where we ask, do we have the boss paying this person things like paying for this person things like taxes, issues to do with insurance, so that at the end of the day we find that this person is really under the control
Right.
of this boss.
All right.
In that scenario, therefore, we say there is an employer-employee relationship.
Okay.
But in the absence of certain things like control, where we do not have the control, the boss controlling what you do, how you do it,
Yes.
at what time you do it. Therefore, at that particular moment, we can say this is a relationship between a contractor or an employer and an independent contractor. And therefore, there is no employer-employee
Kwa
relationship.
hivyo hapo ni ma consultants wanaangukia hapo.
Very good, very good, very good.
Wow.
That can give me clap for me. I've been told very good.
Congratulations.
Yes. A very good scenario that has arisen in the United Kingdom,
Yes.
and I know it will arise here,
Okay.
is the Uber drivers.
What about them?
Uber drivers,
Yeah.
they have argued in the UK
Yes.
that they are employed by Uber.
The company.
Yes, but the Uber company has said these are not our employees.
Yes.
They are independent contractors.
Okay.
Exactly.
Yes. So this debate might find itself here in Kenya,
Yes.
Yes.
where the Uber drivers will be demanding for the employment rights under the Employment Act
Yes.
as employees and not as independent contractors.
We have our guest with us, Advocate of the High Court. His name is Chege Kamau.
Yes.
And we are having a great time this morning talking about employment rights. You got your questions ready? Send them 0702 969 969, or better still, call us 0701 969 969. Shall we
Right.
continue, gentlemen?
Yes, let's
All
continue.
right.
Hiya.
Yes. So we did indicate that it is important for people to understand
Correct.
whether they are an employment contract or not.
Yes.
Both for the employer and the
The
employee.
employee.
Yes.
I would want to emphasize this point. Most employers would believe that if I do not put down the employment contract, I'm safe.
Yeah. Oh.
But my caution to them is that it is very dangerous not to write down an employment contract.
All right.
For instance, if you do not write down an employment contract and this employee decides to go to court after termination, the law will look at this employee as a person who was employed by organization,
Yes.
and will be entitled to all the entitlements under the law. An example would be
Yes.
house allowance.
House allowance. Okay.
Yes.
Okay.
So in a scenario where you have not put it down in writing,
Yes.
and the employee goes to court, the court will award this employee a house allowance, which is equivalent to a third of the salary
Yes.
for every month worked in that organization.
Oh.
And therefore, it is dangerous for the employers not to put their contracts in writing.
Right.
Because
Upon termination,
They are
and we
they
go to
lose.
court.
they'll be the biggest losers.
Correct. Yes. So the courts have pointed out and have settled this matter.
Right.
Yes.
That in absence of a contract, and we
Yes.
have a person who has worked in the organization
Right.
for more than 30 days consistently, that contract or that employment is deemed to be an employment protected under the law.
All right.
All right.
Yes.
So we are past the contract.
Yes.
This is the first document that allows you, to feel like you're part of an organization, and
Yes.
it tells you what you need to do, etc.
Correct.
Stipulated clearly. Even the law, really respects that.
Yes.
So what are some of the basic rights?
Yes.
Basic,
One of
yeah.
the basic, there are numerous, there are myriads of rights,
Right.
but I would want to focus on the basic rights, which you are entitled as an employee. One of it is a salary or pay or wages. Each and every person who is employed is entitled to a salary. Of course, the salaries and wages are agreed upon by the parties.
Yes. That's
right.
And once it is agreed upon by the parties,
Yeah.
then you are entitled to it. And if you are not getting the pay, you have a right really to enforce it by going to court to enforce the right. So one of it
okay.
you are saying is salary or wages or a pay.
Yeah.
There need to be a consideration or payment for the service you are rendering to an organization.
In monetary form, it could be barter.
As long as the parties have agreed,
Yes.
we say that
Yes.
we don't disturb that agreement.
Okay.
Yeah.
Number two,
Yes.
there is a question of you have an entitlement to some leave.
Leave, yes.
We are talking about sick leave. Under the law, each and every person is entitled to at least 7 days
All right.
fully paid sick leave. And if the sickness or illness persists,
Right.
you are entitled to 7 days with half pay salary.
Yeah.
And upon you producing or giving the employer
Right.
a certified report from a doctor
Yes.
Right.
indicating that indeed you are sick. So we're talking about between 15 days sick leave every year.
Yes.
Then you are entitled to what we call annual leave.
Right.
Annual leave.
Yes, which is 21 days for every year worked.
Right.
Now, this one can be, you can get it by going for a leave, or you can agree with the employer
Correct.
that you'll be paid the amount in lieu of
those
going
days.
of those days. Then number 3, we also have maternity leave
Maternity.
and paternity leave.
Very good.
Kevin too. Good morning.
Yes.
Yes, maternity leave is 90 days
90
over
days.
and
yes.
above your annual leave.
Over and above.
Yes, your annual leave.
All
So
right.
we are talking about 51 days.
Yes.
Not 51 days, but
No,
90 plus 21. Yes, so about 111
Yes.
days maternity leave.
Wow.
And now we have also the paternity leave of 14 days.
Oh, yeah, mepewa tu
Is
14
it, no,
days.
is it over and above?
Yes, it is paternity.
Even paternity?
Yes.
It's over and above?
Yes, it is paternity
Allah.
leave.
Yes.
So you have paternity leave and
Yes.
annual leave.
Uh-huh.
Yes.
Okay.
You also are entitled to very important rights that is we call
Yes.
the right to a fair hearing.
The right to a fair hearing.
Correct.
What is that?
It means that whenever your employer has issues with you,
Yes.
he does not just write an SMS to you telling you,
You have.
Danko, don't come to the office tomorrow.
Yes.
You have the right to be informed and to be told that you have violated a certain regulation.
Finished
Yes.
all the tea?
Kindly explain yourself
Yeah.
and put in a representation
Yes.
to defend yourself
Yes.
before action can be taken.
All right.
So whatever the employer does when dealing with the employee, he must afford the employees fair hearing.
Wow.
And when you are having a representation,
Yes.
must it be another employer, or it can be someone even like a lawyer or something like that?
Now, when you're talking about representation, we are talking about, of course, I'm sorry I've used the word representation in terms of the legal jargon.
That's right,
Here we're
that's
talking
okay.
about representation in terms of writing an explanation
Okay.
as to why you did whatever you're accused of.
Yes.
Explaining yourself.
Yes.
Yes.
Yes. Now, under the union practice,
Yes.
trade union practice,
Yes.
when you are in a union and there are these proceedings where you're being accused of certain breaches of
Contract.
the contract,
Correct.
you are entitled to a person attending those hearings from the union. And in that case, therefore, that will be like your representative.
Right.
Really, they are being there to safeguard your rights.
That's right.
In the question of having a lawyer, that will come in when you have been unfairly terminated.
Yes.
And you are entitled to go to court and have a lawyer representing you
Right.
in those court proceedings. Yes.
Okay.
Yes.
This is
So
making
those are
a
the
lot of
basic,
sense. Yeah.
basic
We
rights.
can say those are the basic rights which you must be given
Aya,
when you are an employee.
Aya, going through them quickly. Number one was
Salaries and wages.
salaries and wages.
Yes.
Number two,
Leave, certain leaves.
leaves.
Yes.
And then number three,
The question of a fair hearing.
fair hearing from your employer.
Yes.
I'm going to read you a question from one of our friends who's
Yes.
written to us this morning.
Yes.
Wakili, help me understand the situation. I was working with a company and given a transfer which was not notified earlier, and I was to report to the news station the following day. I declined the transfer and they decided to terminate my services. The company decided not to pay me for the month I had worked, and the argument was that I breached contract of which I had not signed. Help me understand this kindly.
Yeah, so I earlier on indicated that one of the fundamental rights of every employee is a fair hearing.
Right.
Yes.
Really to be treated as a human being.
Right.
And as a human being, you have basic rights which cannot be taken away from you.
Right.
And one of it is you cannot wake up one morning and tell an employee to go to
Kitui,
Mandela
yeah.
or Kitui and start work the next morning.
With immediate effect.
So that it is a question of being fair.
Yes.
Whenever there is a question of unfairness,
Yes. Right.
we say under the law there is unfair termination. And it is upon the employer
Right.
to tell the court and explain to court how it is not unfair.
Correct. All
And
right.
therefore, for our listener,
Yes.
I advise that he indeed has a cause of action because looking at the facts that he has stated to us,
Yes.
that is a total is unfair.
That's unfair.
It is unfair because you cannot wake up and tell me to go to a new place of work
Right. Yes.
without giving me a notice.
What would be the right way to do it?
The right way would be to ensure that you are able to call for a meeting.
Call for a meeting.
Call a
Oh,
meeting.
you the employee.
The employer.
Or the employer,
The
yes.
employer calls a meeting or gives a notice in advance and a reasonable notice
Okay.
saying that next month we want you to go to Kitui. Let us discuss how you'll be going to Kitui
Yes.
and how you're going to start on that work.
Yes.
Okay.
So that from the facts given,
Yes.
it is a question of unfair termination.
Unfair termination.
And therefore he has a cause of action.
Okay.
I would also want to hasten to add that there is a dismissal that is known as a constructive dismissal.
Constructive dismissal.
Where you are not dismissing me, but whatever you are telling me to do are things that are impossible.
Oh.
So that eventually
You will
what
just have, I won't be able to deliver and you
but who
dismiss.
determines it's impossible?
so that you see like a scenario that you have been given there.
Yes.
You're telling me to go to a new station.
The following day.
You know very well that
I have a
I was
family.
not aware.
Uh-huh.
Yes. I was not prepared.
Yes.
Therefore, you are really impliedly
Yes.
dismissing me.
Yeah.
Now,
Okay.
let me just ask along those lines.
Yes.
Let me just ask a question that I think most people would want to ask.
Correct.
What if it was a clause in the contract, but the time I was signing, I just needed a job. I didn't
think
through.
about
And
it.
there was
I
a clause
yes.
number 13, Article J,
Yeah.
that says that we have the right to send you
Out.
without even question
Yes.
to our other branches,
Thank you,
etc.
Danko.
But
Yes.
you needed this job and you just signed.
When
Yes.
because ulikuwa natafuta.
Can you question that
Now,
later, Ama?
of course, unfortunately, under the law,
Yes.
whatever you have signed
Yes.
You have agreed.
binds you.
My God.
However,
My God.
Yes.
if you are able to prove and you are able to argue your case,
Yes.
that you are under some influence,
Yes.
or under some pressure,
Yes.
to sign that contract,
Right.
then you can argue that contract does not bind you on the basis that it is vitiated by that duress,
Wow.
by that pressure.
I like that.
But
I like
as
that.
as a general rule,
Yes.
whenever you sign any document,
Yes.
then it really binds you.
Does
It
our-
is therefore important for every person who is taking out or taking up a job,
Correct.
and is signing a contract,
Right.
to take his time.
Take
and
your time to read, eh?
Read it. You can even seek counsel.
Yes.
And be advised accordingly.
Yes.
So that when you are now putting that ink to paper, you are sure of what you are signing.
So does he have a winning chance, our listener?
Now we need to be able to
Prod
see
further and see,
see.
Oh.
His question says that he never signed the contract. I have seen such statement.
He said, okay, hold on.
That a contract which he never signed.
Yes, he said, help me understand. Okay, I was told I breached contract of which I had not signed.
Very good. Therefore
he has a winning chance.
He has a winning chance.
Yay!
Because the argument will be that this is unfair termination.
Right.
Yes,
I
and the
like that.
employer
Yes.
has a duty when the guy sues. The employer has a duty and an obligation to prove to court
Yes.
that it was not unfair.
Now-
So the onus
The owners.
is on the employer,
On the
Oh,
employer.
the owners,
not
yes,
on
the
the
owners.
employee.
Okay.
Let's just be realistic. Anyone who hears lawyer, we are thinking money and all these things,
Yes.
and we need to involve them. Like, when you are sick, we run to the doctor without even caring how much we are going to spend.
Exactly.
Yes.
You just want
But
to get
Kenyans
better.
don't have this culture, and I'm saying Kenyans because I'm part of them.
Yes.
We don't have this culture of running to seek counsel.
Yes.
We even have brothers who are lawyers.
Yes.
But
Yep.
we will never
Never.
contracts to them for them to. So when you're talking about going through a contract, you've been given an employment
Yes,
contract.
yes.
You've been told sign in 24 hours or 48 hours, bring it back.
Yes.
So what amounts are we looking at when
Correct.
someone has to, just generally,
Yes.
like someone has to go through a contract? If I bring you Bwana Chege, go through my contract and advise me.
Now, generally,
Yes.
lawyers' fees will be dependent upon the value, the subject matter value.
Yes.
And therefore, it will vary from one contract to
To
another.
another, yes.
But I hasten to add that in this country, we have various institutions that are ready to help.
This is true.
So that you can do it through pro bono lawyers. You can also seek counsel from friend lawyers. And they are not unreasonable.
Right.
All right.
You can always agree
Okay.
and get to an understanding.
So it's mandatory,
it.
and it's very important that you seek
It's
counsel
very important.
for every document that you have to sign.
Yes, and when you have a friend lawyer,
Yes.
I think it will be unreasonable for such a lawyer to charge you
Yeah.
some exorbitant fee.
Tafadhali.
And you're just assisting a friend to get a job. So
Yes.
it is a question of reasonableness
Yes.
and the people not fearing to approach the lawyers.
Right.
Okay.
Yes.
Okay.
We
Yes.
got another question on the issue of salary.
Yes.
I don't know if we've talked about this, but we can go ahead.
Yes, yes.
Please remember, you can send your questions to 0702 969 969. We're going to read them out. And if you've got any on Twitter, on Facebook, Super Admin is going to let us know. Someone's asked, what happens when you are on a low salary, but you're putting in more work in a company?
Yes.
So they believe they're on a low salary, but whatever work they've been given by the company exceeds their
The mandate, what they have.
their compensation, the remuneration.
Yes, now I want to reiterate the fact that if you have signed a contract with your employer,
Yeah.
Habari ndio hiyo.
that contract cannot be disturbed by even the courts. So if you decided to agree on that low salary,
Right.
it is unfortunate, but you can always try to renegotiate
Right.
by approaching your employer and putting some sense to him or her and indicating to him, this is what I've been doing for the last 1 month.
Yes.
The salary really is not equivalent to
Yes.
what I'm bringing.
Yes.
And you sit down and agree and renegotiate and sign a better contract.
All right.
But if the parties have already signed a contract, really we cannot disturb. The only thing that we can argue
Yes.
is what I said, bringing in a vitiating factor.
Right.
Like saying I signed it under duress,
Under duress.
under pressure.
After you, they won't blink.
There was
They'll be like,
something. Yes. I was not.
please.
so that you're arguing,
Yeah.
yes, I signed, but this is not my contract.
Aha.
It is not my contract.
Where?
So you have to prove that you are under that duress.
All right.
But if it is signed, it is unfortunate. We cannot disturb it.
The questions are coming in quick, fast, and in a hurry. Wakili, first of all, someone says, thank you for this timely conversation. You're welcome.
Yes.
They're saying, I was employed
Yes.
a few months ago
Yes.
and terminated without due process.
That's right.
There was no meeting, no discussion about my performance prior to this, and pending salaries which is yet to be paid.
Yes.
Serikali's idea.
Yes, that brings us to the question of termination procedure.
All right.
This is an entitlement of every employee that you must be treated fairly.
Yes.
There is the due process we are talking about.
Yes.
Is a question of if you have breached certain rules in the organization.
Yes.
One of the requirement is that there must be a warning letter telling you that you have breached. We are warning you that if you continue in that trend, consequences might follow.
Okay.
So the question, there must be some warning letters.
There must be some warning, verbal, or even a warning letter.
Written.
Okay.
Yes. But again, it is upon the employer to prove that he gave you that notice.
Notice, okay.
Or that warning.
Yes.
And therefore, to ensure that the employer is safe,
yes,
it is important that the employer puts such warning in writing.
Yes. All right.
Now, let's say that the employer has already given those warnings and has now decided this guy must go. Even if you have made up your mind as an employer that an employee must be sacked,
yes,
the law requires you to ensure that you call that person for a meeting.
The law requires.
Yes, a meeting where you're going to discuss his conduct and give this employee an opportunity to defend himself.
Right.
So hii mambo ya kuja ati unakuja unaweka kidole ti uwezi access building umenyang'anywa kadi hapo nje na watchman.
In fact, that is an example of what we call constructive dismissal, where you have not given me a letter.
Yes.
Yes.
You have not sacked me.
But you have locked me out of my place of work.
Out of my place of work, or you have in my office. You have decided in my office I don't have a seat. So that is constructive dismissal.
Unakuja unapata mahali ulikuwa unakaa wameweka water dispenser.
Yes.
All right.
So that you must be given that opportunity to defend yourself.
Right.
Yes.
And it is important that the employer again puts in that in writing. So we should have some minutes of that meeting.
Yes.
Confirming that you attended.
Yes.
Confirming that you are given an opportunity to argue out your case.
All right.
Yes.
And even if the employer has already made up the mind,
yes,
the law says just put that process in motion.
Right.
So we have a meeting.
Yes.
We have an opportunity to put in a representation or a defense.
Correct.
And then after that, you are able to get your entitlement or termination dues.
Okay. Are you a consultant? Are you an employee? Are you an employer? Do you understand the rights that have been read to you? No, I'm kidding. Do you understand that you have rights to whatever you are doing this morning or working at? You have any questions? We have a number. Send it to 0702.
That's right.
969 969. It works both as an SMS and a WhatsApp number.
That's right.
You've been asked, Wakili, this morning.
Yes.
Is it just to be presented with a contract that gives you no room to negotiate your compensation?
Now, we say that unfortunately, most Kenyans do not know that they have the right to negotiate.
Hey, Kenyans, come
So
on
that,
now. You have room, yeah.
Before you sign
kazi.
it.
Lakini
Before you sign it.
If your boss is ngumu sana hii.
Hii ni kazi umepata tu by chance.
Boss, yeah. So you know.
I understand the economic situation of people wanting jobs.
Yes.
But we are saying if you really are competent, it is not asking too much to tell the employer, kindly allow me to look at this contract properly.
All right.
I do not want these clauses. Kindly amend them to fit so that I can be able to deliver.
Wow.
All right.
This scenario really occurs even in a scenario where you are interviewing a person.
Yes.
In terms of a salary. You get to that point of asking for a salary. And you will find this person telling the boss, decide what you just decide what you're going to give me, I'm okay. So it's a question of people knowing their value.
Yes.
Right.
And putting up that fight for what they believe is an entitlement. Because after signing, it will be too bad. We cannot assist you.
Woo.
Yes.
Our legal counsel is here with us this morning to be able to... That's just bad English. Legal counsel. Those are two positives in. It's the same thing, is it not?
Yeah, it's okay. It's okay. Yes.
Yes,
We're talking about employment rights. Are you an employee, employer?
Yes.
There are things that you did not know, especially employees. pay attention. Hata kama we ni mtu wa mjengo. Or maybe you're casual worker. Or maybe you've been working for long and you're thinking of resigning. What are the things that you're going to forfeit?
Yes.
What in the world is gratuity?
Yes, yes.
That one.
Gratuity.
That one, Danko. What is service pay?
Yes.
Stuff like that.
Yes.
Maybe we need to start with service pay because we'll forget someone has sent us a voice note and asked that you explain service pay.
Correct.
Yes.
Now, before I even go to that point,
yes, please.
We were saying that there is that procedure which must be followed,
Correct,
and some entitlements upon termination. So when this boss has decided to terminate you,
right,
we are saying he must call a meeting, give you a fair hearing.
Correct.
And also there must be the question of a notice.
A notice.
Notice that I want you to get out of my organization in the next 30 days. So the law says at least 28 days.
Yes.
However, if the contract provides for more days, then the contract provision prevails. So if your contract
provision prevails.
Yes,
Okay.
so that if the contract says before termination you must be given 3 months notice,
yes,
then you must be entitled, you must be granted the 3 months notice.
Okay. Yes.
In the absence of the notice,
all right,
then you must be paid some payment in lieu of the notice. Yes.
Please pay attention. Are you writing notes?
Yes.
But there'll be a link that will be put up later.
Now, in the unlikely or unfortunate events your boss does not follow the law and terminates you without that procedure, we shall call that process unlawful termination. And therefore, if it is unlawful termination, you have the right to proceed to court and put in a claim for unlawful termination. In the claim for unlawful termination, some of the components which you must be able to ask the court to grant you would be, number one, an order declaring that your termination was unlawful. Once you've gotten that order, then you seek, number two, compensation for unlawful termination. Compensation for unlawful termination, when we are claiming in our court papers, we normally claim 12 months pay.
Yes.
Yeah.
But in most cases, the court will grant you between 6 to 8 months pay. Then you must also be able to get or ask the court to give you if there was no notice, then you must be paid some payment in lieu of that notice.
Yes.
Then you must be paid the salary that was due for that month before termination.
Yes.
If it is not paid, you must also be given what we call a certificate of service.
A certificate of service.
And that certificate of service,
Yeah.
the employer is precluded by the law from writing anything that is negative. So that he must give you a clean certificate of service to acknowledge that indeed you worked in that organization for a period of or a number of years or a period of months in that organization. That is certificate of service. Then now connected to that
service pay,
connected to that question by the listener,
you
are entitled to service pay. Service pay simply means an appreciation by the boss, by the employer,
the boss, the boss
for the work,
appreciate you
for the number of years you have worked in the organization. Therefore, we can call it an appreciation token. How is it computed? You are entitled to a salary for every month worked, a salary for every year worked. So if you have worked for 10 years and you have been earning 50,000, then your service pay will be 500,000.
Yes, so 1 month salary.
1 month salary for every year worked in the organization. I hasten to add,
please,
that our laws were unfortunately amended to entitle persons who are contributors to a pension scheme or NSSF to service pay. And therefore, if your employer has been remitting some contribution to NSSF, you are not entitled to service pay.
All right.
Upon termination.
Wow. Now, okay.
This makes sense. I hope you have been answered this morning, our dear listener.
Just to add quickly,
the
last component there that probably I missed is annual leave.
Annual leave.
So that if you have been terminated and over the last 5 years, you have never taken your leave, then you are entitled to payment for the annual leave days accrued.
Now there's the issue of COVID.
Yes.
The pandemic hit. People have lost their jobs, lawfully, some unlawfully.
Others rendered redundant.
Yes.
Can we talk about redundancy?
Yes.
Go ahead.
Now, what is redundancy?
Yes.
It is a scenario where the organization or the employee's role is no longer useful
Or relevant.
so that it means that your office is no longer required. Your services are no longer required in the
Goes to
organization.
work.
And it's not the fault of the employer. It is out of circumstances.
Out of circumstances.
Out of circumstances, the employer realizes that he can no longer keep you in the organization. And therefore your position or the organization at large has been rendered redundant.
Yes.
So it is no longer useful to keep you in the organization.
But really, who calls people redundant?
So that
So it's positions, not the person.
not the person really.
Yes.
It is the position as well as the organization.
Higher. So I am Tina's employer.
Yes.
I render her redundant, her position redundant.
And he would love to do that.
and she and she goes.
Yes.
And then tomorrow
I
hire
employ
you, and you sit at the same seat where you're sitting
in the same for the
doing
same position.
the same things she was
What
doing.
has
Yes.
happened here?
Now, here we are not saying it is not sacking, it is not dismissal. It is a scenario where looking at the circumstances of the organization, circumstances of the society, circumstances of the economy,
Pesa.
the organization cannot keep you in the organization, cannot continue keeping you in the organization.
Got it.
A beautiful example is the COVID situation.
Yes.
Okay.
COVID comes, factories are closed, businesses are closed. Even if the boss really wanted to keep you,
Yes.
he cannot. Circumstances cannot
Cannot
allow.
allow.
All right.
So there is a specific provision under the law that caters for that kind of scenario of redundancy.
Right.
And this scenario, this situation of redundancy has been litigated severally
Yes.
in Kenya. And therefore, it is an emotive issue.
Wow.
Emotive,
in
by
Kenya.
the way.
Very.
Find you, Kero you.
Very. Yes.
Okay, so we got 18 minutes now to 9 o'clock. We're going to keep the questions coming.
Right.
You talked about Uber, and someone feels... he asks, I'm an Uber driver. I always feel like my rights are violated as Uber doesn't take into account most of my concerns. They claim they didn't employ anyone, yet they control our finances. That is the discounts, and there's no access to money paid by corporate entities.
Right.
Yes.
Explain.
Yes, so
kindly.
I indicated that in the United Kingdom,
United Kingdom, yes.
the Uber drivers have gone to court, and there is a decision really confirming that they are entitled to certain rights.
Correct.
And that the argument that they are independent contractors does not suffice.
Yes.
And therefore, I would advise our listener that it is upon them, it is incumbent upon the Uber
Yes,
drivers
yes.
to come together and be united and probably put in such questions in court.
Umesikia?
So that the court will determine
Yes.
the question as to whether Uber drivers are employees or independent contractors.
Oh, man. All the best, guys.
When that question
Yeah.
is answered,
Yeah.
then we can be able to advise whether they are entitled to what he's claiming or not.
I pray they
But
get
at the moment,
justice.
the position is that Uber insists that they are independent contractors and not their employees.
All right.
Okay.
Yes.
Now, when we talk about what an employee is entitled to upon termination,
Yes.
if I resign, do I forfeit some of those things, or what happens?
Now, when you resign, it means that you have voluntarily decided to leave the organization.
Right.
One of the basic duty you as an employee who is resigning is that you are also entitled, or you are required to give the employer a notice. And if you do not, then you pay the employer
Aha.
Payment in lieu of the notice.
Finally, we have something to say about it. Employers are very happy there.
Finally, employers. Good.
And therefore, also because it is voluntarily
Yes.
leaving,
Yes.
then you are not entitled to compensation.
Yes.
But of course, the issue of service pay, if you are not a necessary or a pension contributor, you are entitled to the same service pay because you have left you have been working.
Yes.
It is documented. You are entitled to such.
Right.
Again, if you even if it is voluntarily you are leaving the organization, you are entitled to those leave days that
Right.
have accrued and you did not take.
Yes.
So you are entitled to that. You are also entitled to the pay for that month.
Right.
It does not mean that because you have voluntarily decided to leave the organization that we deny you your basic rights as an employee.
All right.
It's only that you shall not pursue a claim for unlawful termination.
Do you?
Yes.
But there's one, just before, there's one termination called summary dismissal.
Yes. Summary dismissal is a
Yes.
scenario where
Yeah.
there is gross misconduct.
Gross misconduct.
Yes.
That has to be proven, by the way.
Of course.
Yes.
We said that when there is a claim for unlawful termination,
Correct.
it is upon the employer to prove to court that indeed there was gross misconduct and there were valid reasons
Yes,
for
there
the
you go.
termination.
Right.
Yes.
So summary dismissal will be a scenario where there is gross misconduct
Right.
and really there is evidence and therefore you are summarily dismissed from the organization. But even then,
You're now a summary.
but even then,
Right.
the employer has a duty to give you and accord you a fair hearing.
Even then.
Even then.
No, because-
it
yeah,
is not written expressly under the law, but
Yes.
the courts, decisions of the court have clearly said that even in a case of summary dismissal,
Right.
you do not become a lesser human, and therefore you must be granted your fair hearing.
Wow.
Now,
Yes.
because this is still fresh in our minds about
Yes.
the person who was being relocated to
Yes.
another place.
Yes.
He has confirmed that he's the one who decided to terminate his services.
Yes.
So that still stands as is.
Yes, yes, yes.
Okay.
Yes.
Okay. We have a question. What does the law say about employers who do not offer any allowances? No transport allowance, no housing allowance, nothing.
We said that it boils down to the contract.
Contract.
So if the contract has consolidated all these allowances together,
Right.
then it too bad. The employer was wise and therefore has consolidated those allowances therein.
Right.
However,
However.
if there is no written contract and there is unlawful termination and we go to court, the employer will have a bad day because we shall claim all those allowances that were never given to the employee.
We got a few
So
more.
we're talking
yeah.
about house allowance, we are talking about the annual leave allowance, we are talking about all those allowances and entitlements which are under the law
Yes.
and the employer never provided.
In the meantime, you're being asked, what exactly is house allowance?
Yes, house allowance is an entitlement which the employer ought to give you as an employee to cater for your housing, proper, decent housing. Now, of course, the law will not stipulate what kind of house.
Yes.
So it says decent housing for the employees.
Yes.
Now, in the absence of such an allowance being stated in the contract, then we resort to the law, which says that the entitlement should be a third of your salary
A third.
every month.
All right.
Yes.
So do the math, people. Do the math.
Yes.
And let's see that's how it's going.
Oh, yes. So in matters house helps.
Yes.
The question is, is it mandatory to have a contract written? Because what we do mostly is uko na mtu kuja utakuwa unamka hii masaa unaosha unapika, then 5 years later or 1 year later we are like, tafadhali toka enda.
Thank you.
So it is not mandatory,
Yes.
but
Okay.
it is advisable.
It is
It's advisable.
Because in the case of this house help deciding to go into court, you'll pay hefty amounts because we said that in the absence of a contract, the law will be applied.
Yes.
In the
And
absence of a
therefore,
contract, yeah.
this house help, even though he's a house help, she's a house help, she'll be entitled to house allowance, she'll be entitled to leave allowance, she'll be entitled to all those entitlements which you have enumerated here. And it will be so much, bearing in mind if you have stayed with that person
For so
You
so
understand,
long.
Wakili, what you have just done?
No,
Yes,
it's
true.
Power to the
You
house.
can, let me tell you, that's what you're saying. I think knowledge is power.
Yes, it is.
So has she been? Did she sign a contract?
Yes,
Has she been signing every time when you pay her?
correct.
Has she been signing when she even goes off?
Yes.
Or on leave?
Yes.
Because this has to be proven. Has to be proven if it ends up in the court of law.
Yes, so that it is not mandatory but advisable
Yes.
for employers,
Yes.
even for the lowest cadre of persons.
Yes.
Put that contract in writing, or have some evidence confirming that indeed you are paying such amounts inclusive of house allowance.
All right.
Yes. On the question of
Casuals, yes.
Yeah, casuals.
Yes, we have handled a number of cases where casuals have taken employers to court and argued successfully
Yes.
that indeed they were entitled to annual leave,
right?
They were entitled to house allowance,
Yes.
and all the entitlements. Now, under the law, if you have a casual worker who has consistently worked in your organization for more than 30 days, goes to another 30 days up to 1 year,
Right.
then that casual worker is entitled to the entitlements that are provided for as if his contract is permanent.
Wow.
So that even a casual, if there is evidence of consistency, there is entitled to payments of even annual leave allowances,
Right.
and all those entitlements which I have enumerated here.
Wow.
Wakili, our friend would like to know, when is an employee entitled to gratuity?
Gratuity is a compensation again,
Okay.
that is not an entitlement under the law.
Under the law.
It is an entitlement under the contract.
Right.
Under the contract.
Yes, so that
What is it?
you cannot say with certainty
Right.
that you are absolutely entitled to gratuity pay
Yes.
in the absence of such an entitlement in the contract. So it is not under the law.
It's not under the law.
It is under the contract.
Hey,
So that it is compensation that will be granted or be given to an employee
Right.
who has a fixed contract with an organization.
All right.
After the completion of that contract, the employer decides to give you a gift or a token
Yes.
in
Okay.
the name of gratuity.
All right.
So therefore, it is not an entitlement under the law. You must look at your contract and decide whether it is there or not. If it
Okay.
is not, you cannot sue for it.
There's a friend of ours asking, a wonderful listener asking, everyone's running to labor office today, nowadays,
Yes.
after being a terrible employee.
Yes.
A friend has a nanny who would come home drunk and days late from her off day. The labor guys are threatening her from here to Timbuktu.
Yes.
How do we get protection against such employers?
Protection would be gotten if you follow this counsel that put things in writing.
In
That
writing.
is number one.
Number one.
Number two, even if is a house help, treat that person as a human being.
Exactly.
By
Please,
being fair.
Yes.
Being
So
fair.
it is a
Yes.
question of even though this person is not competent,
All right.
let us have evidence of a warning letter. Let us have evidence of a meeting that was convened for the purposes of discussing the conduct.
Yeah.
That even before firing this person, you afforded that person a fair hearing.
Yes.
If you have evidence of such, then these labor officers' threats will not work for you.
Yes.
Because you have followed the law. You have followed the procedure of terminating.
Right.
So it's a question of the employer being careful and ensuring that there is fairness
Yes.
in the processes and following due procedure, even if
Following
it's
due
a house help.
procedure. All right.
Even if you are dealing with the house help.
And
Yeah,
go
so on redundancy,
Right.
I would want our listeners to be aware that when redundancy occurs,
Yes.
we said that during this COVID period, there were so many organizations that collapsed, and therefore
Yes.
most employees were rendered redundant.
Redundant, yes.
However, I am sure that not many employers were able to follow the due process
Yes.
when carrying out redundancy.
Right.
Okay.
So one of the basic things that must be done in passing is that there must be a notice of the redundancy.
Yes.
So you must be given a notice. If you are in a union, then your union must be served with that notice. If you are not in a union, you must receive the notice personally.
Yeah.
Then number two, you must be granted your annual leave that has accrued.
Yes.
You be paid. The law, by the way, says be paid in cash.
Be paid in cash.
Yes, be paid in cash.
Cash money, yes.
Yes. Then
Yeah.
number three, there must be a criteria of selecting who is to go and who is to be left. And the criteria must consider the issues of seniority,
Eh?
the issues of experience,
Yes.
the issue of reliability.
Uh-huh.
Those are the certain criteria that must be followed
Yes.
or must be used by the employer when deciding who is to be rendered redundant or not.
And this is law.
Yes, that is a law. There must be a criteria.
Okay.
Therefore, you cannot just wake up and say everyone is going, or I am leaving this person and the others are going. When there will be a question as to whether that redundancy was in accordance with the law, the issue of criteria that was used shall come
in question.
and you'll have as an employer to explain what criteria you used to determine who goes and who remains.
Right.
Then there must be the payment of what we call severance pay.
Severance pay.
Our listeners, it is important for them to distinguish between gratuity pay, service pay, and severance pay.
And it's not the spelling.
It is not
They
the
have
spelling.
to get definition.
Yes, service pay and gratuity, we say it is a compensation.
Yes.
Yeah, correct.
Appreciation.
Yes,
Yes.
For work done for many years.
Umefanya kazi, yes.
Severance pay here is, we can say it is that payment that is paid to you because now that relationship has been severed,
For the inconvenience of
has
that
been cut off.
Yes.
So you get severance pay. And how much do you get? It is a 15 days payment for every year worked in the organization.
So half month salary
Correct.
for the number of years that
Correct.
you worked. Okay.
Correct.
What was the other one that was 1 month's
It is service pay
service pay is
Service
1
pay.
month's pay
for every
year
year
worked.
You're a
But
good student.
severance pay
Yeah.
It
is
is
half
15
the
days.
half the year half the
a
month
yeah.
pay
for the
for the
number
years
worked.
Okay. So if I worked 5 years in a company,
Yes.
earning 50,000,
Yes.
it is 25,000 times the 5 years I have worked.
Correct.
Right.
Then lastly, this one is not in the law, but over the period of time when this matter of redundancy has been litigated, I said it has been litigated severally, the courts have now come up with a new requirement of consultation. And the courts have said that when you want to carry out redundancy,
All right.
the employer must sit down and consult the employees, and they agree and come up with a consensus and an understanding that indeed we really wanted you to be in our organization, but circumstances cannot allow.
Yes.
So that this employee goes home with that understanding and that and is happy
Yes.
that they were explained to why they must go home.
All right.
So consultation.
A friend of ours is asking you this
Yes,
morning,
yes.
is it fair for an employer to reduce an employee's salary without the employee's consent?
It is not allowed, it is not tenable, it is illegal.
When the president turned our tables around and reintroduced what he had, I think this was the, help me, Danko, the what do we pay? VAT.
Yes. Oh, he reduced.
Yes.
When, bringing it, taking it out and then bringing it back.
Yes.
A lot of people had their
Salaries
adjusted.
That was legal.
Now, it will be a question of the employer arguing that I have done this because of operation of law.
Yes.
Okay.
So it is the law that has forced me to do this.
Yes. Okay.
But we are saying anytime you do some deductions without the consent,
Correct.
even where the law has provided for,
Yes.
without the consent,
Without the consent.
it is illegal. You must get the consent,
So how do we-
consensus
Yeah.
and agreement about that reduction.
So what can be done?
What should be done is
Yes.
that, as indicated, there must be consensus before these things are done.
All right.
So that it is incumbent upon the employer to sit down with the employees,
Yes.
explain to them that because of the financial situation, in the next 3 months, we shall have a salary cut. And it is agreed.
Okay.
However, you don't do it really without consent, without a meeting.
All right.
Yes, it must be. You don't do it arbitrarily.
All right.
You must get the consent and a consensus before you do that.
Good.
If you don't do, if you do it without a consensus, then you are facing a claim
All right.
for the refund of the salary cut.
All right.
Okay.
Yes.
Fantastic. I see time is really, really rushing. And of
Yes.
course, we can't do all this in
Right.
one sitting. So we can just dive into WIBA,
Yes,
Work
yeah.
Injury Benefit Act.
Yes.
And again, if
Yes.
you need his number, text us on 0702 969 969 for further consultation.
Yes. So WIBA, it is a wide law, but I just wanted to share a few important things that our listeners would take home.
Right.
Number one is that in 2007, there was a law that was enacted, Work Injury Benefits Act. What is the purpose of this law. The purpose or the objective of this law is to provide provisions of the law that will cater for scenarios where a worker gets injury in the course of employment and is probably injured, is incapacitated, is disabled, or even dies. So the law now, this law comes in to provide compensation for work-related injuries. In other words, we call them occupational injuries yes. or diseases.
Okay.
So this law was enacted, and immediately it was enacted, LSK went to court on the basis that some provisions of that law were unconstitutional.
Right.
And that matter went to the High Court, Court of Appeal, and eventually, recently, Supreme Court rendered a decision, now settling the matter.
Yes.
The question that was before court was as to whether this act, which says that when we have a claim,
yes.
a worker's injury claim,
yes.
it should not go to court in the first instance.
Okay.
It should go to the Director of Occupational Safety and
OSHA.
Health, OSHA. So LSK was arguing that it is unconstitutional for the law preventing people to access the courts.
Yes.
So the High Court had agreed with LSK.
Yes.
Court of Appeal declined, and this matter went to the Supreme Court.
Yes.
And now the settled position of the law is that that law is proper. It is not unconstitutional. And therefore, when you have a claim for an injury that is work-related, you go to the director that is in charge of occupational safety and not the court in the first instance. However, if you are aggrieved, you now go to the court on appeal.
Yes.
To the court on appeal.
Yes, but not in the first instance.
The first instance. So
yes. So generally, what are we talking about when we say work injury benefits?
Act, yes.
We are talking about that compensation which you will be entitled to as a worker when you suffer some injuries, when you contract a disease, or when you die in the course of employment.
All right.
Yes. So once such things happen, then this law entitles you to put in a claim for compensation.
A good example is when we saw the flower farms a while back.
Yes.
And it was on TV.
Correct.
When
That
the workers were exposed to chemicals that they used to preserve the flowers.
Yes.
Right.
So if we have evidence, medical evidence, that this disease that these flower workers have contracted is as a result of their work, then they have a claim under the Work Injury Benefits Act.
When we talk about the injuries, must they happen at work?
They must be work-related.
Work-related.
Yes.
So me walking to work and I fall into a ditch.
Yes.
I was walking to work.
Yes.
Is that not work-related?
But you see, in that scenario, there are certain other people who are responsible for your injury. An example would be the reason why you have fallen into that county government.
You're kidding
so you have
me.
you have a cause of action against other parties, not your employer. But any injury that is occurring in the course of employment, during the work, that becomes a work injury, related injury, and therefore you are entitled under the Act for compensation.
Wow.
Yes.
This discussion can go on forever.
Exactly.
But I know he's got to rush out and attend to other matters.
Yes.
Plus our DJ is looking at us like, what's going on?
What's going
it's
on
going to
with
be
you
happening soon.
Yes.
Wakili, thank you. As always, it's a pleasure.
I'm also grateful to have to come here and share my knowledge to the masses.
I know you have some questions, but we've given you his number. If you can call him or text him or forward that particular question to his phone, he's going to be able to respond. He's a really cool guy.
Yes.
He's a cool guy.
A text will do.
A text will do, Please don't call him. I have remembered, Musimpigie simu, please. Yes. But you know, there are people who have, they're really tough questions. They've been injured at work, but sometimes the employer makes it turn out like it's their fault.
Yes.
They were careless.
Yes.
Like you're in a hotel and you pour hot tea on yourself by mistake. It's your fault.
No, we said that it is the duty. It is the duty of the employer to prove that indeed
there was
negligence on the part of the employee,
Got
and that he provided adequate measures to prevent the injury.
Yes.
All right.
Yes. I hasten to add that when you have an injury, work injury claim,
Yes.
that this law requires you to put you in your claim within 12 months. So do not wait for 10 years, then you now
you come later.
Yes.
But if I am heartbroken, because that
Okay,
can
really? Wakili, thank you.
can that be an injury?
And also
Emotional
If I hit you
distress.
with this microphone, it will be an injury.
and also for employment claims,
yes.
you must ensure that you come to court within 3 years. Failure to which it becomes a time barred.
Are you
Time
hearing
bar.
this? You're hearing this? What, Aya, fanyeni hivi. Let's just release our wonderful friend.
Yes.
And thank you.
Asante.
He's
Asante.
going to be back in the
it's-
next show.
It's such an honor, knowing that he's a believer,
Right.
and he's using his ability. He may not preach on the pulpits, but
Correct.
he's using the law to educate us.
Yes.
And therefore, we cannot be even grateful enough
Kabisa.
for the work that you do coming here to us. We are
Yes.
so grateful.
I'm also
Yes.
grateful for the
Yeah.
opportunity.
Yes.
And we pray that the radio will grow and grow.
Almost
Hallelujah.
Become
Shanda.
a big
Yes.
Mpaka tupate house allowance ya 10 million each.
Join us in the next legal episode of Should I Pay Dowry? It's coming up soon now. Thank you, Wakili. You're amazing. Asante.
Join Tina and Zuki and Danko on Pearl in the Morning.
Weekdays from 5:30 a.m. to 10 a.m.